What is going on, everyone? It is Mark Reel Jr., the Fathers Rights Attorney, and we're here with another episode of the Fathers Rights Playbook. And today, first episode we filmed at our San Diego office. I have San Diego attorney Sandy Mead. Sandy, how are we doing today?
Fabulous, thank you.
Awesome, awesome. So Sandy and I were talking beforehand, what would be something that's valuable for our listeners and viewers? And we were talking about the value of settlement. And Sandy's truly one of the masters of negotiating a good settlement for our clients. So I'm going to turn over to you, Sandy, with this question is, what is the difference between agreeing to something or coming to a settlement before a hearing or going to a hearing and having the judge make a decision?
There's a world of difference, first of all. The most important thing I tell everyone whenever I'm dealing with settlements and trying to negotiate any kind of meet and confer, you're the one with a skin in the game. Judges don't have any skin in the game. Yeah. So keep the power in your hands and decide what you want. When it comes to custody and visitation, you know that that Friday afternoon is precious to you. To a judge, it's just another Friday afternoon. So if you're negotiating and something's more important to you, you get that into an agreement, all of a sudden you have the power and you take it away from any chance of being lost. Yeah. Where if you go into court, you never know what they're going to do. They might. I
think that's a big point. A lot of times when you go in front of a judge, you're going to get something that's cookie cutter. And you may get one or two customizations, but you're going to end up with an every other weekend. You're going to end up with a 2-2-3 or something that's standard, week on, week off. And it doesn't account for, hey, you coach their baseball team on Thursday night, so you having them every Thursday is a big deal. Or you have family does something on Sunday afternoon and you traditionally have always had them. You can't get that if you don't work through it and settle something.
Exactly. And even on property division, sometimes you just don't want to spend thousands of dollars having somebody else make a decision about your stuff. Yeah. When one bank account is more important to you than a house, for instance, or the house is the most important thing and you don't really care about a retirement that might come down the road. Putting your money where it's important and focusing on what's important and giving yourself the power to say, this is what I want, this is what I don't. And usually you can meet on good terms with both sides. If you have people like me that can stand in there and say, this makes sense, and we're not trying to do anything rash, we're not trying to get away with anything, but if you give it to a judge, they could do something completely different and you have no power. Then it's done, the bell's been rung.
Yeah, well, finances, that's the big one when it comes to coming to some sort of agreement. Ultimately, it's a math equation. Yeah. And I always tell people at the end of the day, the worst outcome possible is the judge cuts everything in half. And you lose equity, you pay penalties, you do all these things, where if the two of you, through your attorneys or just in conversation, can say, this is important to me, this would be easiest, if you do this, I'll do this, a lot of times both parties come out ahead of where they would if we're splitting everything down the middle.
Right, exactly. For instance, with quadros, you have to hire an expert and spend all that money to hire an expert to divide assets. If you're looking at these accounts and they're almost similar and identical, just divide them and each keep your own. You save thousands of dollars just not having to have that expert because you took the time to pay attention. Judges aren't going to take that time. They don't have the time available. They're going to say, divide everything 50-50, have a quadro, get it done, and you're going to spend extra money just to get the same result.
Yeah, we just had one of those with a state pension where one had worked for 12 years, the other had worked for, it was like 10 and a half years. So it was, and the one who'd worked for 10 and a half made a little bit more money. They were almost equal. Yeah. And you could end up in a situation where you're paying these penalties, you're paying a couple $1,000 for quadros, you're doing all these things, where just a conversation, you can come out with a more positive outcome for both. Yeah. It's not a zero-sum game.
No, exactly. And then you have enough money to go on vacation and celebrate that it's over and move on and have a great life. Yeah. We're all about making sure that you move on and have everything set and do the best you can for where you are. And the difference with that, I think one thing that people don't know in custody battles, just because you didn't get exactly what you wanted the first time doesn't mean that you're done. You can always go back and readjust things and modify things. And orders are set in place for when you can't agree, you have something to fall back on. But you also have that negotiation. And what I try to teach my clients, and I think is really important, is how to document things so that you can have a stronger case in those future hearings and how you can avoid some pitfalls and some traps that might be set for you.
Yeah.
And that's the value where I think that we give our clients is we teach them how to handle their cases and how to move forward and get the best situation they can, and how to correct whenever things go astray, because they do from time to time, how to get back on track and get everything on course where you're really winning at the end.
Well, I think what gives us a big advantage a lot of times is the negotiated settlement is almost always the best outcome for both parties, but a lot of times, especially with us, like there's a willingness to litigate if necessary. And if the other side knows that, we know attorneys, we know firms who are not going to take it to trial. And to have an attorney, have a firm that's hey, we'll take it to trial, we're going to be proficient in trial, we're going to get you a positive outcome, is ultimately going to get you a better deal because the other attorney knows what the alternative is.
Yes, exactly. And I think I just had that happen in court just the other day. We were ready, we're going forward with the case. We settled 90%, but there was that 10% we just couldn't get an agreement on. And I knew the strength of our case. I'm like, we're just going to go and leave it with the judge. Before we even got to argue, make oral argument, the judge gave us a preliminary, which was exactly what I had offered 5 minutes before we got into the courtroom. We won without even having to argue that case. It was beautiful. And that's when I feel really good for my clients, because I know what they're going to get when it's consistent. And they have 20 years of experience of me watching courts do what they do. And I love our people, I love our judges, but I don't love them to have all the power. I want me to have the power. I want my clients to have the power.
Keep the power with the clients.
Exactly.
So Sandy, thank you so much. So I hope everyone got a ton of value out of really the power of settlement and how it can be a positive, even if you're not getting exactly what you want. So for Sandy, thank you so much for your time today.
No problem.
For all our listeners and viewers, thank you for watching another episode of the Fathers Rights Playbook. We'll see you guys again next week.